B District Court is now in session. This is Magistrate Hillary Braley presiding. Okay. And I need you unmuted at the jail. There we go. Can I have your name, please?
For the record, my name is Thomas Snyman II. I'm the natural person, I'm the living man. How we doing today, Ms. Braley?
We are upright, if nothing else. So, okay. And you said your name is Thomas Styron.
The second.
The second.
And then I'm the natural person.
Right out of the gate, we're introduced to a living man in Michigan running the classic sovereign citizen script. He insists he's a natural person, not the legal name on the docket. This opening sets the tone. Instead of addressing the charges, he's challenging identity itself. The court, calm and procedural, simply wants a name for the record. Already, you can see the disconnect. He's arguing philosophy. The court is operating on law.
Recalling case number 19S00472, that is the state of Michigan versus Thomas Ulrich Styron, the second, you said. And also calling 24W001025, that is the township of Ypsilanti, also versus Thomas Ulrich Styron. So state your name for the record.
So, for the record, my name is Thomas Styron II. Is not the name you have attached to this case is not me. I believe that's a state created entity, Your Honor. And I'm not, me being a living person, my name is in proper punctuation. I don't have a all caps name nor
Okay, I'm going to cut you off right there. Okay.
I don't have no contracts with the state of Michigan at all, period. And so I was wondering.
As the magistrate recalls the case numbers, he pivots into the familiar separate entity argument, claiming the name attached to the case isn't him, but a state-created fiction. This is textbook sovereign rhetoric. The court doesn't bite. Jurisdiction is explained plainly. You're in Michigan. The incident happened in Michigan, and you're physically before the court. Personal and subject matter jurisdiction. Established. Debate over.
To wonder about those at the moment. What I am doing, you have a show cause hearing on the matter ending in 472, which is the retail fraud charge. I'm showing a balance of $210 on that. And then what you're being arraigned on, that is what I am here to explain the charge against you, is a citation issued on April 2nd, 2024 at 9:24 in the evening. That charges that you operated a motor vehicle on North Ford Boulevard at or near Russell Street with no license on your person. Do you comprehend the charge against you?
I do not. I don't even own a license. I canceled my license.
Now the court lays out the charges: retail fraud balance, and a new citation for operating a vehicle without a license on his person. Notice the structure. The magistrate is methodical, focused, and clear. Meanwhile, he circles back to jurisdiction again. It's a strategic stall, but courts don't litigate jurisdiction from YouTube law theories. They rely on statutes and court rules, not wordplay.
Operating a motor vehicle without having a license on your person. So, I'm not asking if you agree with this. I'm not asking if you have a license. I'm asking if you understand the words coming out of my mouth as far as what this charge is.
The charge is accused me of not having a driver's license on my person, correct?
Correct.
Well, from my understanding, I need a driver's license if I'm in commerce. I was traveling home.
Okay.
I wasn't doing business at all. And also from my understanding, I don't need a license to do that.
And your overstanding is incorrect, sir. But we are not going to get into that for now. You are saying that you have understood the words as far as not having a license on your person. It is a misdemeanor charge with a maximum penalty of up to 93 days in jail, a $500 fine with court costs, or both.
So this is under the assumption that you guys have personal jurisdiction and subject matter jurisdiction over me, right?
Yes.
So
At this time, the court is going to set a pre-trial date for you. That will be before Judge Washington.
ma'am, can we prove the jurisdiction first before we go ahead with setting a trial for that entity or a pre-trial for that entity?
I hear you, and at this point you are appearing in front of the court. You have put your name on the record, and yes, we are setting a pre-trial date for you.
I did put my name on the record, and my name that I put on the record is not the same name that you have.
When asked if he understands the charge, he dodges into "I canceled my license years ago." That's not a defense, it's an admission. The magistrate clarifies. This isn't about agreement, it's about comprehension. The key here is procedural discipline. Courts don't argue ideology. They confirm understanding, then move forward. He keeps trying to turn it into a debate. The court keeps it procedural.
June 26th.
So the documentation that I have published, recorded in the documentation I have published and recorded on the record, on the state of Michigan record, that says what I just told you, that I'm not who you have, that I'm not the name you have attached to that case, that's I need to bring that with me, is what you're saying? It being already recorded and on the state of Michigan records. Is that good enough?
Whatever documentation you have,
Mm-hmm.
bring with you to your pre-trial date. That is what I am telling you, yes. So. And again, that court date, June 26th? Okay. Will be June 26th at 9 a.m. before Judge Washington. The court will enter that you are standing mute to all charges at this time.
So we're just assuming jurisdiction, though, correct?
Yes.
How? From my understanding, that has to be proved before we even proceed with anything else.
He introduces the traveling, not driving in commerce claim. This is another common line, arguing that licenses only apply to commercial activity. The magistrate shuts it down cleanly. Your understanding is incorrect, and this isn't the time for that argument. She's not dismissive. She's maintaining courtroom efficiency. This is arraignment, not a constitutional symposium.
Correct. The court will also set a personal recognizance bond in this matter. Basically, you are promising to show up for that June 24th court date at 9 a.m. over Zoom before Judge Washington, where you will have your pretrial. Okay? So at this point, your hearings are concluded. You are free to stand up and tell the jail that you are finished.
So I need to be there under threat, duress, coercion of going.
When the pretrial date is set, he demands jurisdiction be proved before proceeding. That's not how criminal procedure works. Jurisdiction is presumed under law unless legitimately challenged with valid legal grounds, not slogans. The magistrate reiterates, "You've appeared, your name is on record," and the case moves forward. The machine of procedure keeps rolling.